I'm going to try to keep this class short and sweet, to try to keep it to no more than an hour. Just want to share some important information with you in preparation for your supplementary exam. You realize this is your last opportunity, that you have to write the subject. It's being phased out. If you don't pass now, you have to transition to the new program. I'm not quite sure what the implications of that is. Gilbert Hoybep, your faculty officer, will be able to assist you in that regard. But I think it is more important that you pass than that you worry about what are the implications going to be if you have to transition to the new program. So let me quickly share my screen. Okay, can you see the screen? Just give me a thumbs up if you can see the screen. Okay. So just remember, while I'm teaching, I'm focusing on the window that has the screen where I'm typing, not on the window that shows the class. So I won't see if you raise your hand. If you have a question, if you want to ask me something, just speak up, just shout out, switch on your mic, and talk to me and get my attention. Let's make that a bit bigger. There you are. So the layout, first of all, students are always asking for a scope. I think by the scope, they mean the layout. If you're not speaking to me, please just make sure your mics are muted. Emilia, you've just joined, welcome. Make sure that all mics are muted. Okay, so there you have the layout. Sorry, this is not true or false. It's not, you don't have true or false questions. I've got that wrong, my bad. This is multiple choice. Question 1 is multiple choice, not true or false. I worked on last semester's. So 15 multiple choice questions. Take your time with your multiple choice. Take your time. Read the question carefully. Read all the possible answers, and then start working by way of process of elimination. So read the question and the possibilities, and then there's likely to be one that's obviously not the correct answer, then you cross it out. Then you read everything again and cross out the next one until you've reduced it to 2 possibilities, and then you compare them carefully. Because sometimes just multiple choice people, a single word can make a difference to your answers. So read through the multiple choice questions carefully. Take your time with them. Question 2, my standard, a collection of short knowledge-based questions. These are literally straightforward questions. Everything is in the study guide. It's all there. Question 3, I'll get back to these questions. I just want to go through the layout. Question 3, structured application. Is there a partnership? Yes or no? Motivate your answer. Question 5, question 4 is a giveaway. That's 10 marks I'm giving you. And I will be very upset with you if you don't get 10 out of 10 there. Identify the legal concept. I give you the description. You must tell me what the legal concept is. You've had this question before. So no reason for you not to get 10 out of 10 there. Question 5, I'll talk about this soon, is a case study. It might seem intimidating, the fact that the total marks is 25 marks, but it's 4 separate questions. It's actually 1 separate question, and then the last 3 are sort of related to each other. Question 5.1 and 5.2 are separate questions. Then there's another case study for 10 marks. Representation of a partnership. You had that in your first opportunity exam, and the answers are shocking. Absolutely shocking. I'll go through that again as well. And then question 7, question 7. Short little case study, 5 marks. It's about lease agreements. I just threw that in there because I was short 5 marks. So I needed a further 5 marks. You are all repeaters. Everybody is repeating that did registered for business law this year, in 2024, also did it in 2025. 2023, sorry, I've got my dates wrong. All these questions that are in the exam, I have asked you before. Dig out your old assignments, look at those assignments, work through those assignments. The memos were shared at the time. So go back to your assignments. The answers are all in your assignments of the last 2 years. Okay, so that is the layout. Then something that I picked up during when I was marking the first opportunity exam is, and I don't know why, you seem to confuddle the law of purchase and sale and the law of lease, law regarding lease agreements. It's as if in your first opportunity exam, you didn't know what the difference is between a contract of sale and a contract of lease. Not even talking now about the fancy legal concepts, just linguistically in English. Surely you should know what the difference is between sale and lease. So when you're reading a question, please make sure that you read correctly. And if I'm asking you what is the essentialia of a lease agreement, don't tell me what the essentialia is of purchase and sale, and vice versa. What is the most important difference between sale and lease? To test you here quickly. Somebody, in the class, quickly switch on your mics and answer that question for me. What is the most important difference between purchase and sale and lease?
It's ownership.
What about ownership? That's only going to give you half a mark.
So with purchase and sale agreement, ownership belongs to, okay, with a lease agreement, ownership still belongs to the lessor and not the lessee. Yes.
Yes.
And then with a purchase and sale agreement, ownership transfers from the seller to the buyer.
Absolutely, absolutely, Emilia. I would give you full marks for that. Another way, so they actually boil down to the same, but they're two possible answers. What is the most importance between purchase and sale and lease? So purchase and sale, ownership will pass. I'm not going to type out everything that you said it now. You said it in more detail than I have. In lease, it doesn't. It stays with the lessor. I'm going to save time and not type all of that out. Or alternatively, another answer which boils down to the same is a purchase and sale agreement is permanent, whereas a lease agreement is only for a period of time. So, bearing that in mind, another question quickly. If Reagan, Mr. Kuala, enters into an agreement with me that he will rent my car forever, is that a lease agreement?
No, it doesn't qualify as a lease agreement.
Why not? You're correct, but why not?
Because contractually that is supposed, it is recognized as a purchase and sale agreement if the ownership is indefinitely the leases.
Okay, Emilia, you've got the understanding. I wouldn't necessarily, although I suppose if he's leasing it forever, then the ownership will pass. So it's implied that the ownership, but your understanding was correct. If he enters into an agreement with me to lease my car forever, it's not a lease agreement, because forever, a lease agreement must have an end date. Or if it doesn't have an end date, at least there must be a provision of notice or some procedure to follow to bring it to an end. A lease agreement can never be forever. Lease is always temporary. Are you all with me? Do you understand that? Mr. Kuala, are you with me?
Yes.
Mr. Eliphas, are you with me?
Yes, ma'am.
Yes.
Okay.
Yes, we understand.
Okay. Mr. Meadow has also since joined. Welcome, Mr. Meadow. I did record right from the start. I will share the recording. So back to what I was saying. In your first opportunity, you confused lease and purchase and sale. These are two different parts of the work. Keep them separate. Always read carefully. So let's talk about question 3, structured application. You've had this before. Structured application, what do I mean by that? I give you 5 short scenarios. So just as an example, has a valid partnership come into existence? Motivate your answer. So how do you answer this? Let's use this particular one, has a valid partnership come into existence. Can be valid partnership, purchase and sale, can be valid lease agreement, whatever. Let's focus on this one. How do you determine whether a valid partnership has come into existence? First thing you look at is the contract valid? Your 5 requirements for a valid contract. Parties must have contractual capacity, performance must be possible, performance must be legal, consensus, there must be consensus, and formalities if required. Because if the contract itself is not valid, obviously it's not a valid partnership. Once you've determined that the contract is valid, you look at the essentialia for a valid partnership. Are they contained in the scenario that I've given you? What are the essentialia for a valid partnership? There must be contribution. There must be a joint business, and there must be profit sharing. So if all of those are present, you've got a valid partnership. One of those is missing, partnership is not valid. Let's give you an example. Okay, just give me a second here. Just want to go into some documents and find an example quickly. Save some time, then I don't have to type. Let's try this one. A, B, and C agreed to sell Kapana in order to earn some pocket money. Unfortunately for them, the meat is really expensive and they end up making a loss. Is this a valid partnership? Ms. Meadow, what do you think? Is this a valid partnership? Anybody to help her out? Do you think this is a valid? It is valid. Why do you say it's valid?
Because they both agreed.
They agreed. And what about your other requirements? They agreed. First of all, okay, let's take it step by step. Is this contract valid? anything funny about this contract? They agreed. Are the other requirements met? Is it legal to sell kapana? Talk to me, people.
Yes, it's legal.
I didn't give their ages, so you can assume that they have got contractual capacity. Now you've got a valid contract, but now let's look at this contract. Did they contribute? Is there contribution?
No.
Look carefully.
I mean, they did expend money to buy the meat, which ended up being expensive.
Yeah, okay. I don't specifically refer to the contribution here, but we can assume that they both, maybe a little bit vague there. They agreed to sell it to earn pocket money together. There's a joint business. They end up making a loss. But they agreed to earn pocket money. The fact that they ended up making a loss, profit, they still intended to make and share a profit. The fact that the profit didn't ensue, that they actually lost money, does not mean that now suddenly it's not a partnership. Yes, it's a partnership. There was a hope. I'm quite flexible with what you say in your motivation, but I would like a little bit more than just saying, yes, it's a partnership, yes, because they all agreed. That on its own is not a suitable motivation, because let's look at this one. A, B, and C agree to sell kapana on campus in order to raise money for the Nust Hockey Club. Is this a partnership? All three of them agreed. Does that make it a partnership?
Yes, it does.
Why, Mr. Meadow, why are they raising the money? Why are they selling the kapana?
In order to raise money for the Nust Hockey Club.
It's not a partnership.
Emilia, it's not a partnership. Why is it not a partnership?
Because it's not for profit sharing, it's for fundraising.
It's not. So to get back what you said earlier, when your motivation was because they agreed, that on its own doesn't make it a partnership. Here they also agreed, but you've got your requirements for a partnership: contribution, joint business, and an intention to make and share the profit. In this particular instance, they're raising money for the Nust Hockey Club. So your third requirement, profit making, is not present.
So, Miss, can you say that the contract is valid, but it is not a partnership?
That is absolutely perfect. It is a valid contract, but it is not a partnership because there is no profit sharing. Last example before we move on. A, B, and C enter into a partnership agreement to enter dinosaurs. Is that a valid partnership?
No, it's not valid. It's not a partnership. It's a partnership, but maybe it's not a valid contract because you are not, they are not able to deliver. What do you call it?
Emilia, you are quite right. You are quite right, except your wording was wrong. You said it's a partnership, but it's not a valid contract. The validity of the contract comes first.
Okay.
If it's not a valid contract,
then it's not a valid partnership.
Then it's not a valid partnership. You can't have a valid partnership based on an invalid contract. And as far as I know, we are not currently in 2025 capable of selling dinosaurs. So is this a partnership?
No.
Not
what
a
is the word that is used again? What is the word that is used again when you are not able to deliver? Impossibility of something.
Performance.
Not impossibility.
Possible, or you can say impossibility of performance. Doesn't matter. I'm not sticky there about the precise words of performance. So if the contract is void, then the whole partnership, you can't have a valid partnership on a void contract. And in this particular instance, as you said, Emilia, impossibility of performance, can't sell dinosaurs. Okay, is everybody with me? Do you get the idea of what I expect in this question?
Yes, ma'am.
Okay.
Which question is this one, ma'am?
That's question 3, the structured application.
Okay.
Identify the legal concept. I'm not going to do any explaining here. You've had this before. I give you the description. You must tell me what the legal concept is. 10 marks I'm giving you for free. You better get 10 out of 10 for this. Question 5, a lengthy case study. Not actually a lengthy case study. A single case study with 4 different questions based on that case study. Read your case study. Read all 4 the questions before you start answering. Something that I've picked up with my business law students, when it gets to purchase and sale, this question, I can tell you, it's about purchase and sale, the various aspects, the various duties. Of the seller. Seller has got various duties. 2 of the most important duties is the duty to keep the thing in safe custody, which is coupled with the passing of the risk rule. And then there's another separate duty. And don't confuddle these 2. There's another separate duty. The duty to guarantee against latent defects. The duty to keep the thing in safe custody is a duty which comes into consideration if there's a contract of purchase and sale and delivery is not immediate, the seller must keep the thing in safe custody until it is delivered. The passing of the risk rule, however, that goes with this. The passing of the risk rule says that the risk will pass to the purchaser when the contract is perfecta. When is the contract perfecta? 3 requirements for a contract to be perfecta. Make sure you know those. I'm not going to write them down here. You should know what the requirements are for the contract to be perfecta. So there are 3 requirements. The fact that the risk has passed does not relieve the seller of his duty to keep the thing in safe custody. Because this risk is the risk of accidental damage. If the risk is passed, it means that the implication of this is when the purchaser takes delivery, if the thing has been damaged or destroyed, they have to accept the damaged thing or nothing at all, and are still liable to pay the seller. But this is accidental damage. So if I have sold a car to Mr. Eliphas, and we agree that he will only collect the car next week, between now and next week, I must keep the car in safe custody. The contract is perfecta. We've agreed that it's purchase and sale. There are no conditions. We've agreed on the thing, and the purchase price has been identified or specified. Remember, perfecta doesn't say you must already have paid. It doesn't relate to payment, just relates to that the price must be ascertainable. So there are no conditions in the contract. The price is ascertainable, and we've agreed on the thing. So our contract is perfecta. So the risk has passed to Mr. Eliphas. Tomorrow night, there's a hailstorm, and the bike is damaged by the hail. Must he still pay me or not? Did I have control over the hail?
No.
The risk has passed to him. There was accidental damage. Must he still pay me?
Who is the car with? Sorry, maybe I missed that.
Sorry, the car is still with me. He hasn't taken delivery. The passing of the risk rule is only applicable before delivery. Once he's taken delivery of the car, then it releases me of all duties. We'd agreed that he would only take delivery of the car next week. So the car is still with me. Car's parked in my garden, in my driveway. But the risk has passed to him. Must he still pay me?
No.
Why are you saying that?
Because it wasn't the fault of the seller when the car got damaged. It's because of natural causes.
Exactly. So it's accidental damage. So it's the other way around. The risk of accidental damage passes to the purchaser. I want to make sure I wrote it correctly here. Yes, the risk of accidental damage will pass to the purchaser. The contract was perfecta. The risk of accidental damage has passed to the purchaser. I had no control over the hailstorm.
So does that mean the purchaser must still pay for it? Does that mean the purchaser must still pay for it?
That is the implication of the passing of the risk rule. The purchaser must still pay for it.
Mm.
And this is where traditionally my students tell me, but I don't understand that. Why don't you understand that? Because you're thinking with your heart and not with your head. Think with your brain, not with your heart. That is how the law works. Full stop. You're not understanding it because you feel it's unfair. How can this be? Now it's been damaged, but he must still pay. That's unfair. I don't understand it. Is that correct? Am I correct here?
Mm-hmm.
Don't think with your heart.
So when is the contract perfecta? Is it once the client signs for it, or once the purchaser receives?
You should know the requirements for a contract to be perfecta by now. Let's go back. The seller must keep the thing in safe custody until it is delivered. So this is applicable before delivery. If it's taken delivery, this whole rule is no longer relevant. The passing of the risk rule means that the risk of accidental damage will pass to the purchaser. When is the contract perfecta? You should not be asking me at this stage when is a contract perfecta. You should know this by now. When is a contract perfecta? When the thing has been identified, the price is fixed, and there are no suspensive conditions. So this does not relate to delivery or payment or anything. The moment those three aspects are met, the thing has been identified, the price is fixed, and there are no suspensive conditions. The contract is perfecta, and the risk passes to the seller or to the purchaser, and the purchaser must pay the purchase price even if the thing has been damaged or destroyed. That's the way law works. So don't, because you feel it's unfair, say, I don't understand. Think with your heads, not with your hearts. Are you with me, Emilia?
Yes.
Now the same question. Let's work on the same facts. He bought a motorbike from me. The contract is perfecta. The bike is still with me. I haven't delivered it yet.
So, sorry, ma'am, before we go there, I just wanted to ask. So this question 5 is 4 questions. And so this, for example, this just falls part of one question only.
Yes, yes.
So you need to mention the duties of the seller, and then you need to mention the what? The passing of the risk rule, and then the requirements for the contract to be perfecta. And then after that, then you need to
then apply to the facts. Apply to the facts. So has the risk passed? Must he pay or not?
Yes.
So in
Then
the
you have
first
to-
instance, in the first instance, it was accidental damage. The risk has passed. He must still pay. But yes, you identify the duty of the seller, you describe the duty of the seller, you refer to the risk rule. Risk passes when the contract is perfecta. What are the requirements for a contract to be perfecta? And then you apply to the facts. So facts, let's change them slightly. So the contract is perfecta. But now what happens is I left the bike standing outside in the street with the key in the ignition, and the bike was stolen. Must he still pay me?
No, ma'am.
Why not?
Because okay, so the seller has to keep the thing safe. So the seller did not keep the thing safe because he left the key in the ignition and left it outside.
Exactly.
Which could have been avoided.
Exactly.
Easily avoided.
Exactly. 100% full marks there. So you would set about your answer in the same manner, starting off what is the duty of the purchaser to keep it in safe custody. Then you explain the passing of the risk rule, look at the requirements, is it perfecta, yes or no, and then you apply to the facts. But in the two different examples I've given, your final answer will be different. If it was destroyed by hail, purchaser has to pay because it was accidental damage. If it was stolen because I left it outside with the key in the ignition, purchaser does not have to pay. I did not keep it. I did not comply with my duty. I did not keep it in safe custody. Are you all with me there? Everybody with me? Just speak to me
Yes.
here. Eliphas Jr. is with me because
Yes,
his
ma'am.
answer there was very good. Okay, so let's move on then to the guarantee against latent defects. Now remember, this is a separate duty. So don't confuse the two. The seller also has a duty to guarantee against latent defects. When does this, what is a latent defect? And there are certain requirements for a defect to be a latent defect. You should know these requirements. If you don't know them, go and study them tonight still. I'm not going to go over them. This is supposed to be a revision class, not a teaching class. That bike that got damaged by the hail, the paintwork got damaged by the hail, that is not a latent defect, because that damage did not exist at the time. It's something that happened after we contracted. But if I sold Mr. Eliphas a bike and I told him the bike is in perfect working condition, and we subsequently finds out that the brakes don't work, that is a latent defect. a problem with a bike and you've got the requirements, list those requirements. You get 5 marks for listing those 5 requirements. Studying that you should have studied, you just write them down. So the same approach to the question. You identify the duty.
You are referring to the requirements of the latent defect, right?
Yes, yes, yes. I've moved on. This is now a separate sub-question. We finished with the question dealing with the passing of the risk rule.
Yes,
I
yes.
I told you it's
Yes,
one
yes, I'm with
case.
you.
Yeah. I told you it's one case study, but it's got different questions. So we finished with the question relating to latent up to the passing of the risk rule and keeping it in safe custody. We're now at the second question, a separate question, latent defects. So
Okay.
he collected the spike and a day later he realizes the brakes don't work. How do you answer that question? You refer to the duty. Seller has a duty to guarantee against latent defects. You explain to me what the requirements are. You decide based on the facts whether this was a latent defect, yes or no. If it's a latent defect, he has a claim. If it's not a latent defect, he doesn't have a claim. As simple as that. So go and study those requirements. Not going to teach them to you now. It's not, tonight is not a teaching class. And then the other 2 little questions, 3 marks and 4 marks. That's just based on the same scenario where I changed the fact slightly. But the 10 mark and 8 mark question, those are the 2 big ones there. Representation of a partnership. Case study, usual case study that there's a partnership, they entered into an agreement, a partnership agreement indicating that only one of the partners is a managing partner, has the capacity to enter into the contract or to represent the partnership. And now one of the other partners buys something without permission. And the question is essentially, must the partnership pay? Is the partnership liable for the contract? This question was in the, not this question, but a similar question was in your first opportunity exam. And the questions were answers were absolutely shocking. This question has also been in previous assignments. Go and find those assignments and the memos. The memos were made available to you. How do you go about answering this particular question? What are the requirements for a partnership to be bound? Contract must be valid. Entered into on behalf of the partnership, and there must be authority, or it must be in the scope of the business of the partnership. Now, when you start answering this case study, remember to address those 2 requirements. Will probably only be half a mark or 1 mark each. You don't need to go into all 5 of the requirements for a valid contract and discuss them in detail. But I do allocate marks for you telling me that the contract is valid and it was entered into on behalf of the partnership. But that's straightforward. The bigger issue comes in with that bit. And the concept of sorry, my bad. Express authority or implied authority. In order to get maximum marks, you must address both of those. Is there express authority? Yes or no? So what is
No.
express? What is express? You can't say no if you don't have the case study in front of you. That will depend on the facts of the case study. Express authority is when our partners are Eliphas, Emilia, and Pythia, and the partners decide to send Eliphas to buy a racehorse. They instruct him to go and buy a racehorse on behalf of the partnership. Is there express authority?
Yes.
There's express authority because they literally express authority, a specific instruction to enter into a specific contract. In most instances in these case studies, although sometimes I do give the facts indicating that there was express authority, if there's express authority, the partnership is bound, as easy as that. In most case studies, that won't be the case. I won't give sufficient facts to indicate that there was express authority. Now, implied authority, and this is where you seem to struggle. Let's say Mr. Eliphas has a bike, a motorbike, and I take it away from him. Does he still have a bike?
Still
Come,
belongs
answer
to
me.
him. It still belongs to him, yes. He just doesn't have it.
But he doesn't have it. He had a bike and I stole it. Does he have a bike?
No.
He had a bike. I stole it. He doesn't have a bike. And this is what you seem to struggle with when it gets to implied authority of partners. Now let's say Eliphas, Emilia, and Pythia are in a partnership. In terms of the law of partnerships, all partners have implied authority to represent the partnership. But now you agree that only Eliphas may represent the partnership. If you've agreed that only Eliphas may represent the partnership, may Emilia represent the partnership?
No.
No.
If you've agreed that only Eliphas may represent the partnership, may Pythia represent the partnership?
No.
No.
So you had implied authority, but because of your agreement, it was taken away from you. If it was taken away from you, do you still have it? Come, this is not so difficult, people. It's taken. Eliphas had a bike. We took it away from him. Does he still have it?
No, he doesn't. So no, they don't have implied authority once they agree that only Emilia has authority.
Exactly. And that is what I don't understand, why you don't understand it. If there was a partnership agreement that took implied authority away from a particular partner, they no longer have implied authority. And that's where you all lost your marks, because you all told me he has authority. He didn't have authority because it was taken away from him. The fact that the authority was taken, let's just go back to my notes here. So you need to first look if there's implied authority. If there is implied authority, if there was no partnership agreement and there's implied authority, the partnership will be bound. But now there's no applied authority. Remember that. So the partner does not have implied authority. However, the fact, the contract is, yeah, sorry, carry on.
So the partner doesn't have implied authority because authority was taken away from him, but the contract is still binding, right?
We're getting there. You're correct, but you've now just jumped ahead. But you're correct.
Okay.
So now the contract is unauthorized, but it can still be binding if it is in the scope of the business. So yes, you were quite correct. I just wanted to bring in that sentence. So there's no implied authority, but because it's in the scope of the business, it is still binding. The fact that it is in the scope of the business, and it's important that you understand this to get maximum marks for this question. The fact that it's in the scope of the business means it is binding. But now suddenly, so let's say Eliphaz, Emilia, and Pythia have a fishing business, and only Eliphaz may represent the contract, the partnership. So we've established now Emilia does not have authority. Pythia does not have authority. But Eliphaz buys fishing equipment for a fishing business. Is it in the scope of the business? Come, yes. Work with me. He buys fishing equipment for a fishing business. Is it in the scope of the business?
Yes, it is.
It's in the scope of the business. Because it's in the scope of the business, they have to pay Mr. Nangolo who sold it to them, because it's binding. But Emilia still does not have implied authority, and Pythia still does not have implied authority. The fact that it's in the scope of the business doesn't suddenly give you your implied authority back. It remains unauthorized, but it is binding. Are you with me?
So let's say, yes, we are with you. Let's say maybe the partner bought a car for personal use.
Car for personal use, not in the scope of the business.
Not in the
Partnership
scope
will
of the
not,
business.
yeah, partnership will not be bound.
Okay.
But partner bought fishing equipment in the scope of the business, partnership is bound. Everybody with me?
Let's say the partners they all have implied authority and they can all make decisions. But then partner,
Yes, I'm sorry, carry on.
but then the partner then buys a car for personal use with partnership access. Does that qualify as a binding contract for the partnership?
No, it won't. My case studies won't be as complicated as that, but that is a very insightful question. Your implied authority as a partner is the implied right to represent the partnership in the business.
Bona fide.
Yes. So even if there's no partnership agreement making any changes, you all have implied authority. That doesn't mean you could go and use partnership money to buy a car for your personal use. But you can buy partnership money to buy a car for the partnership to use as a delivery vehicle. Do you understand that? That's fairly straightforward.
Yes. Yes, ma'am.
Yeah. Yeah. So the implied authority doesn't cover, isn't a blanket you can now go and spend partnership money on absolutely everything. You still have to be representing the business and acting on behalf of the business and in the scope of the business. But my case studies aren't as complex as that. I will, in the course of the evening, find an old question somewhere based on, I think I will take the one that was in the first opportunity exam and just share with you the extract from the memo, just so that you can see what information, how much detailed information you need to give me for 10 marks.
Okay. So this is question 6, right? 10 marks.
Yes.
Okay.
Question 7 is a short little 5-mark question about lease agreements, essentially the rights of the lessor to terminate. May they just kick you out, yes or no? No, they may not. They must give you notice. Okay, that covers everything. Students? Yes, Bethia?
So right now, this explanation was what we actually had to do on the question 6, the last one. The last
Yes,
question, basically.
yes,
Oh,
yes.
okay.
And nobody did that. So I will share the answer to question 6 so that you can see what you were supposed to do.
Oh, okay, ma'am.
Okay.
Then
We're a
last
little.
question.
Miss,
Yes.
the last question is on lease.
Yes, it's
Miss?
a 5-mark question. Whoa, let's not shout out. You weren't listening to me, Eliphas. I literally told you just now, minutes ago, what the question was about.
No, ma'am,
You
I
weren't
wanted
listening.
to
Oh.
ask one last question.
Oh, okay. Sorry. My bad. What did you want to ask?
On this now, the implied authority thing. So let's say the person that does not have authority ends up buying now the car for personal use. But then the other partners are like, okay, we can use the car for business. They decide that later on. They're like, okay, it's fine. The car deal is fine. Or something along those lines.
Yes, I'm following exactly what you're saying. What can they do under those circumstances? Because if this partner did not have implied authority, and it's not in the scope of the business, it was for personal use, it means it is not binding. But if it's not binding and the partnership decide it's actually useful, they would like to keep it, what can they do? They can ratify the contract. Ratification, giving authority retrospectively. But if a contract is binding to start off with, don't tell me they can ratify or must ratify. No, they mustn't. If it's in the scope of the business, they don't have to ratify anything because it is binding. Let's put that down here.
Okay, thank you, ma'am.
Can still be binding if it's in the scope of the business. And I'll just write here for you because a lot of you made this mistake. There is no need to ratify the contract. So don't go telling me they must ratify. They don't have to ratify anything. It is binding. It's binding, but there's still no authority. The fact that it's binding doesn't suddenly bring back the authority. Emilia, you were still saying something and I interrupted you?
Yes, ma'am. I'm still at question 5. I just wanted a bit more clarity because question 5 has 4 questions. The duty of the seller, the passing of the risk.
That's 5.1. That's 5.2.
5.2 is the passing of the risk.
No. Duty to keep in safe custody and passing off the risk is one concept. They go hand in hand. They're not
Okay.
separate. So that's 5.1.
Mm-hmm.
That's
And then
5.2.
Oh, okay. I'm not looking there. I was looking in my notes.
I'll save this page and put it on the WhatsApp group. That's 5.2. 5.3 and 5.4 are small sub-questions which also relate to that but change the facts slightly. It's sort of 5.2 is the big question, and then 5.3 is, will your answer be different if, and I change the facts slightly.
Okay. Okay, I see. Okay, because I was wondering what the other 2 questions were.
So this comes from the same unit. These are separate units. This is one unit. Oops. This one is one unit in the study guide. This is a different unit in the study guide. But 5.3 and 5.4 also relate to that unit. Changes the facts slightly. For example,
Okay.
will your answer be different if the thing was sold food stewards?
Okay.
So they follow on from 5.2. Okay, people, thank you for joining. I hope you listened. I hope you listened well, because I have now literally told you what is in the exam. Apart from the multiple choice questions, I didn't tell you what the multiple choice questions are. But otherwise, I literally shared with you what is in the exam. So I really hope this was beneficial. Go back now to the areas that I discussed here in the class and concentrate on them, or go over them again. Make sure you know those requirements for a latent defect, etc., etc. If you come across anything in the meantime before the exam that you get stuck on, that you don't understand, whatever, please don't hesitate to ask on the group, and I will try my best to answer. Otherwise, I wish you well, all of you. Please.
Thank you very much, ma'am.
Do this for me. I need you to pass. Reward me. Do it for me if you're not doing it for yourselves. Thank you.
Thank you, ma'am.
Take care. Happy studies. Bye.
Thank you, ma'am. Bye.